a very important judgment coming from the High Court of Guwahati, in which the court ruled that the bona fide purchasing dealers could not be denied input tax credit simply because the sellers, the suppliers, they failed to deposit the tax collected. One of the key features of the GST is the concept of ITC, which allows the businesses to claim credits for the taxes paid on the inputs used in the course of business, which then later is used to offset the output tax liability. However, the implementation of GST and the ITC provisions has not been without many challenges. One of the significant issues that have arisen is the denial of ITC to the purchasing dealers when the selling dealers, when the suppliers, they fail to deposit the tax collected from the buyers with the government. This issue forms the crux of the case at hand. If we talk about the facts of this case, this case is a writ petition which is filed by the National Plasto Molding, which is the partnership firm, versus the state of Assam and others. It has some connected matters too, which brings forefront the contentious issue of ITC denial under GST regime. The two provisions which are challenged by the petitioners upon their validity is the section 16(2)(c) and section 16(2)(d) of the CGST Act. If we talk about section 16(2)(c) of the CGST Act, these provisions basically outline the conditions for claiming ITC. Okay, section 16(2)(c) states that ITC will be available only if the tax charged in the respect of such supply has been actually paid to the government, either in cash or through utilization of input tax credit, admissible in respect of the said supply. 16(2)(d) states that the recipient has furnished the return under section 39. If we talk about the transaction in question, the petitioner had entered into the transactions with the suppliers who were registered under GST regime. These suppliers have issued valid tax invoices for the transactions. This is a very crucial point, as it demonstrates that petitioners had, on the face of it, complied with all the necessary requirements for being a legitimate transaction under the GST regime. Then what happens? Where the controversy starts? The partnership firm here receives show cause notices from the tax department, from the office of the tax officer. These notices proposed to deny the petitioners input tax credit on the specific ground, as we all know, which is that the selling dealers, that the sellers, that the suppliers, they have failed to deposit the tax collected from these transactions with the government. The situation here creates a dilemma for the petitioners. Despite having conducted seemingly legitimate transactions with the suppliers and possessing valid tax invoices, they are still facing the prospect of losing their input tax credit due to the actions of the suppliers, over which they have no control now, because the transaction is now over. The petitioners argued that the provisions in question were analogous to the section 9(2)(g) of the DVAT Act, Delhi Value Added Tax Act. This provision had been challenged and interpreted by the Delhi High Court in the case of On-Quest Merchandising India Private Limited versus Government of Delhi. In this case, the Delhi High Court had held that the bona fide purchasing dealers could not be punished for the defaults of selling dealers, for the default of suppliers. The petitioners contended that this principle should apply to their case as well. Furthermore, the petitioners argued that denying the ITC to bona fide purchasers for the seller's default is arbitrary, is unreasonable, is in violation of Article 14, which guarantees the equality before law. The respondent's position, interestingly, they did not dispute that the controversy raised in these writ petitions, as it was covered by the Delhi High Court's decision. right? Because what happened in this decision was then went to Supreme Court. An SLP was filed, where the SLP was denied, and this case got so much presidential power. That's why the respondent did not argue much. The legal issue here. What was the legal issue in front of the Guwahati High Court? If we talk about the first issue, that was whether 16.2c and 16.2d of the CGST Act are valid and constitutional, insofar as they allow the denial of input tax credit to bona fide purchasing dealers when the suppliers fail to deposit the tax collected with the government. This issue touches upon several fundamental principles of law, of the tax law as well as the constitutional law. If we talk about the first principle, that is the principle of equity in taxation. The second principle is doctrine of impossibility. Right. Third principle is constitutional guarantee of equality before the law. And the fourth is the balance between preventing tax evasion and protecting legitimate business transactions. Sorry for the interruption, a call came. So the principle of equity, we were talking about the principles. We talked about four principles. That is the principle of equity, the doctrine of impossibility, and the constitutional guarantee of Article 14, and the principle between preventing tax evasion and protecting legitimate business transactions. So first, now we will talk about the principle of equity in taxation. This principle asserts that the tax system should be fair and just. In the context of this case, of the Guwahati case, it means that the taxpayers in similar situations should be treated similarly. This principle of equity in taxation has basically two aspects, from which we will discuss only one, which is called horizontal equity. This means that taxpayers with the same ability to pay should pay the same amount of tax. In this case, it would be so inequitable if two purchasing dealers, both acting in good faith, were treated differently based on solely of the actions of the suppliers. So this is the very important point here. Okay, and the second one is the vertical equity, in which I'll tell you in which what happens. This refers to the idea that the taxpayers with greater ability to pay should pay more taxes, just like an income tax. That we won't be discussing here. The second doctrine is of the impossibility. The legal principle states that the law should not require impossible actions. It's often expressed in the terms of lex non causit ad impossibilia. So what happens here, which means that the law does not compel a man to do so, which he cannot possibly perform. So in the context of this case, that the suppliers actually deposit the tax or not with the government would be, and the purchaser asking them to do so would be an impossible actions, because they don't have any control over the sellers, as because it is the obligation of the sellers, and after the transaction is complete, the purchaser have no obligation, or they cannot ask the supplier. The court's decision here recognizes that this impossibility and interprets the law in a way that doesn't place such an unreasonable burden on the purchasers, on the buyers. This constitutional guarantee of equality, and now we're talking about the equality. Article 14 of the Constitution guarantees equality before the law and equal protection of the laws. This fundamental rights prohibits unreasonable or arbitrary discrimination. In our case, treating bona fide purchasers the same as those might be colluding with the suppliers. We are separating the dealers in two parts. One is bona fide and one is the one who is colluding with the suppliers. We cannot put them two in the same position, right? The court's decision here upholds the Article 14, ensuring that the law does not discriminate against honest businesses based on the factors beyond their control. And the last principle is that the balance between preventing tax evasion and protecting legitimate businesses transactions. This principle recognizes that while the government has legitimate interest in preventing tax evasion, This must be balanced against the need of to protect and facilitate legitimate business transactions. Denying input tax credit to all the purchasing dealers when the sellers default without considering the purchaser's good faith would tip this balance too far in favor of the tax collection, at the expense of whom? The legitimate business activities. It could create a chilling effect. People will fear before entering into such transactions with the suppliers because because due to the fear of the losing their ITC. The court's decision here strikes a balance by allowing the tax authorities to deny ITC in cases of fraud or collusion. They cannot deny the ITC in case of bona fide purchase. This approach maintains integrity of tax systems while minimizing disruption to honest businesses. Right. So now we will be analyzing what was held in the case of the presidential case, the Onquest case, which was referred in this judgment. Right. The first point. First of all, we will understand the section 92G, which was referred in that judgment. The section said that no tax credit shall be allowed, no input tax in the case of GST, to the dealers or the class of dealers unless the tax paid by the purchasing dealer has been actually deposited by the selling dealer with the government or has been lawfully adjusted against the output tax liability and correctly reflected in the return filed for respective tax period. So this was the section 92G, which was challenged in the Onquest case of the Delhi High Court, which was which had presidential value over this case. So what was the Delhi High Court's decision here? The Delhi High Court made several crucial observations and rulings. First, it stated that the section 92G of the DVAT Act fails to make a rational classification between bona fide purchasing dealers and those are not, rendering it vulnerable to invalidation under Article 14. That means the section 92G is hit by Article 14. Then if we talk about the burden, the onerous and unreasonable burden to the purchasers by requiring them to ensure that the suppliers deposit the tax correct, that the suppliers deposit the tax which were collected by the suppliers from the buyers to the government. How can they bear such burden to know that? Third point is a purchasing dealer cannot be expected to anticipate which selling dealer will default on tax deposits or somehow ensure tax deposits after transaction. That would be impossible. That would hit the doctrine of impossibility. The court also observed that the department has other provisions like section 40A of the DVAT Act to deal with such fraudulent transactions where the purchasing dealers and sellers are colluding. Right. So they can go for that section, they can act in that section. Treating the bona fide purchasing dealers and non-bona fide ones, actually they equally, if we treat them equally, the bona fide and non-bona fide, it will violate Article 14 of the Constitution. And to save section 92G from unconstitutionality, the court read down that the expression which is listed in the section dealer or class of dealers, this expression should not include the purchasing dealer who has bona fidely entered into the purchase transactions with valid suppliers, and there is no mismatch of transactions. As a result, department is precluded from invoking section 92G to deny ITC to a bona fide purchaser who has transacted with a registered selling dealer issuing a proper tax invoice. And if the seller fails to deposit the tax collected from the buyer, the department's remedy is to proceed against the seller, the supplier, not the bona fide purchaser. Right. This decision was upheld by the Supreme Court when it was dismissed, when the Supreme Court dismissed the SLP filed against it. That's why the Guwahati High Court took so much presidential value of this case. Right. Now let's examine what was held in the case of Guwahati High Court. If we talk about the observations and the held part of the Guwahati High Court ruling, First was that the Guwahati High Court set aside the show cause notices which were issued to the SSE. Second was that the interpretation of GST provisions, as the court held that the tax department is precluded from invoking the provision to deny ITC to the purchasing dealer who is bona fide and entered into the purchase transaction with the registered selling dealer who has issued tax invoice correctly. And also the court provided a caveat that the tax department is free to act in those cases where the purchaser and the seller, they have colluded and the purchaser is not bona fide. In that case it will work, right? And at last the court disposed of the writ petition, right? So the court gave judgment in favor of the assessee. So this was the end of the video. You will see the link for the newsletter or the judgment for this case law here at the end of the video or in the description box. And stay tuned for more judgments videos and for more knowledge on this channel. And do subscribe, and you will find the link to the WhatsApp update channel in the description box. You can join it to get the latest updates on the taxation and IPR, right? Thank you for watching this video, and we'll see you in the next video.